Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. In this video, we will discuss the landmark Supreme Court judgment in Sanjabij Tari v. Kishore S, Borcar Anr. 2025. This decision clarifies critical aspects of cheque dishonour cases under Section 138 of the Negotiable Instruments Act, 1881, strengthens legal enforceability, and introduces procedural reforms to speed up trials. Case background. The appellant, Sanjabij Tari, advanced a cash loan of Rs 6 lakh to Kishore S, Borcar, who issued a cheque in discharge of this liability. Unfortunately, the cheque was dishonoured due to insufficient funds. After serving a statutory notice under Section 138 NI Act and receiving no payment, Tari filed a criminal complaint, setting off legal proceedings that eventually reached the Supreme Court. Lower Court's decisions. Trial Court, April 2007, convicted Borcar under Section 138, holding that the cheque was issued for a legally enforceable debt. Sessions Court, September 2008, upheld the conviction, rejecting Borcar's claim that Tari lacked financial capacity to advance the loan. Bombay High Court, Goa Bench, April 2009 acquitted the accused in revisional jurisdiction, questioning Tari's financial capacity and the issuance of a blank cheque. Tari challenged this acquittal in the Supreme Court. Arguments and Supreme Court observations. Arguments of the parties. Appellant, Sanjabij Tari argued that the High Court wrongly acquitted the accused, ignoring the statutory presumptions under Sections 118 and 139 of the NI Act. Respondent, Kishore Borcar claimed the loan was in cash exceeding Rs 20,000, allegedly making it unenforceable under Section 269 SS of the Income Tax Act, 1961. Supreme Court's key observations. 1. Legal enforceability of cheques. The court reaffirmed that cheques are reliable and widely used modes of payment. Once cheque is issued and its execution is admitted, the statutory presumptions under Sections 118 and 139 of the NI Act automatically apply in favor of the holder. These can only be rebutted by strong and cogent evidence from the accused. 2. Clarification on cash loan validity. Cash loans exceeding Rs 20,000 are enforceable under the NI Act. The court clarified that Section 269 SS of the Income Tax Act does not invalidate such loans, and the NI Act provisions prevail. Thus, the cheque dishonour claim remains valid, and any income tax penalties are separate. 3. Procedural reforms to expedite cases. No precognizance summons are required before magistrates take cognizance of a complaint under Section 138. Compounding offences, the court outlined clear percentages of the cheque amount to be paid at different stages for compounding, ranging from 5% to 10%, depending on trial progress. Probation of Offenders Act. Courts may consider probation for accused persons, balancing punishment with rehabilitation. Restoration of conviction. The Supreme Court restored Borcar's conviction under Section 138 of the NI Act, emphasizing several critical points. 1. Concurrent findings of fact. The High Court had erred by reappreciating evidence and revisiting concurrent findings of fact without any material irregularity. The Supreme Court clarified that revisional jurisdiction is not meant for reassessing evidence but for correcting gross injustice. 2. Acknowledgement of debt. Borcar's signature on the cheque and the absence of sufficient evidence to rebut the statutory presumption confirmed the existence of a legally enforceable debt. 3. Guidance to lower courts. The Supreme Court directed the trial court to proceed with conviction in accordance with Section 138. Consider the Probation of Offenders Act where appropriate, taking into account the accused's background, the amount involved, and the possibility of repayment. Ensuring fairness, while restoring conviction, the court balanced strict enforcement of cheque laws with rehabilitative measures, ensuring that the accused could still make amends through compounding or probation if conditions were met. In essence, the restoration reinforces that dishonouring a cheque cannot be avoided by technicalities, cash loans are enforceable, and courts have discretion to allow rehabilitation under probation, making the ruling strong and balanced. Future impact: 1. Stronger legal presumptions. Complainants now have a reinforced position in cheque bounce cases. 2. Clarity on cash loans. Large cash loans are legally enforceable under Section 138 NI Act. 3. Faster and more efficient trials. Procedural reforms are expected to reduce pendency and ensure timely justice. This judgment strikes a balance between strict enforcement and fairness, impacting creditors, debtors, and the judiciary. Conclusion: the Supreme Court's ruling in Sanjabij Tari v. Kishore S. Borcar Anr is a landmark judgment for cheque bounce cases in India. It strengthens cheque enforceability, clarifies the validity of cash loans, and reforms procedural rules for faster justice. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.